So very pleasant good evening to honor present here. I'm Tarang Arora,
Thank
just
you.
junior conductor at Just Corpus Law Journal and the host for today's session. I, on the behalf of whole team of Just Corpus, welcomes you to today's session, which pertains to red jurisdiction, a very interesting topic. Before we
A
delve into
pleasure.
today's discussion, let me brief you about Just Corpus and the eminent guest of today's session. So Just Corp is an edtech platform established in 2020, comprising a collection of legal platforms. The platform aims to consolidate various aspects of law under a single umbrella. With an impressive reach of ranging 600K clicks per month, Just Corpus introduced and engaged to the needs of growing needs of law students. As part of an initiative, Just Corpus introduced an interdisciplinary law journal, which is known as Just Corpus Law Journal. Now, turning a focal point to today's primary thing, that is our guest speaker, who is none other than Advocate Raj Kumar Yadav, sir. Sir is a practicing advocate at Supreme Court of India as well as different high courts of India. Sir has done more than 100 plus appearances in Supreme Court of India in the last calendar year. Sir has teached a lot of students who are now serving as esteemed judges, IPS officers, and IAS officers as well. Sir is a assistant professor of economics at Delhi University. Sir has done his schooling from Mumbai and is graduate from University of Mumbai. And apart from that, Sir has done his law degree from Delhi University. Without further ado, I would like to hand over the floor to Sir for his invaluable insight on the very pertinent topic that is digital. Over to you, Sir.
Thank you. Thank you. Just a small correction. I was assistant professor in Delhi University, not East. So that was
So,
very good. So hello friends. I think you might be high on your spirit. You all guys, whatever persons are there, and how many of you have joined from different states or maybe from different countries in the world. Firstly, I'm feeling very awesome for being called at this platform. And I really thank especially that girl Sakshi and all of you, those who are arranging this meeting. And I wish that the Just Corpus is having a bright future for all their future endeavors. As far as this session is concerned, I will concentrate myself only and only near the area of rates. We will try to understand what is the basic meaning of rate. Thereafter, we will try to understand where in the Constitution of India we can find rates. Then we are going to discuss why we need rate. Thereafter, we will discuss what is the connection between fundamental rights and rates. Because until and unless we understand what is the basic of fundamental right, it is useless to talk about rates. Secondly, thereafter, we will try to understand what are those persons who can file rate, whether a layman individual or a person who is having some problem can file rate, or any person who is interested can file rate. We will take this also. Thereafter, we will try to discuss, is there any time limit for filing a rate? If yes, we will discuss. Thereafter, we will try to dwell upon how many types of rates. We will end this session with how many types of rates, discussing the rates. So I hope so that I am very clear on my topics because I don't want to waste time. So again, I welcome all of my audience throughout the country and throughout the world. And especially again, I thanks Just Corpus and I wish Just Corpus to be one of the brightest future and having a wide spectrum of audience throughout the world. I wish that Just Corpus reach from north to south and east to west of the world. Well, whether I'm audible, guys?
Yes, sir.
Yes, please. So we will start with what is the meaning of rate? Suppose someone asks you why rates are included. Then we need to understand what is the basic meaning of rate. The basic meaning of rate is an order that is informal order. So what do we mean by the term formal order? Formal order itself clearly indicates that the rates are being issued by an authority. So what are those authority? Those who issue rates. Those authorities are in India right now. They are high courts and the highest court of the land, that is Supreme Court. Earlier, the rate was being issued by even the kings. Why? Because they were dictating the country. So this was the basic meaning of formal order. That is, now what is the basis of writ? Whether writ has any basis or simply we have copied from other constitutions of the world and we have included in our constitution. If not, and if yes also, then also the question arises that what is the basis? So what is the foundation of it? Now there are two foundations, namely rule of law and odi altrum partem. Rule of law indicates that none person or no person is above the law. Say for example, if I say that you being a president of India don't have license to kill. You being a president of you don't have license to kill. Even you being a prime minister of India don't have license to kill. That is why we need to understand what is the basis of rule of law. If you are killing someone, if you are creating nuisance to someone, if you are creating problem to someone, this someone may be a layman person or maybe state or maybe a body, corporate body, any person can be there. So if you create problem, you need to face the law, or the institutions such as police, the institutions such as judiciary. The moment you create a problem, the law set into the motion. Now, what is the basic meaning of odi altrum partem? See, the Constitution of India is very nice. It is very nicely drafted. We can say that it is the bride, or we can say, the moment you get married, the bride is very awesomely, we can say, उसको हम सजाते हैं, like that. So it is on the basis of this only odi altrum partem has been included. Now, what is the meaning of odi altrum partem? See, the Constitution of India says that if you want to decide something, that means we need to have someone against or in front of us. We will take an example. Assume that your bike has been theft. Your bike has been theft. Now you will try to lodge an FIR or you will go to lodge a complaint in police station. Now, the moment you lodge an FIR, you set the law into motion. That is great. Now, the moment you set the law into motion, police will file an FIR under whatsoever section of CRPC, that is 154. Thereafter, they will move this particular FIR to the courts. Now, court, only on the basis of your complaint, cannot decide the case. They will try to call the second party. This is the basis of odi altrum partem. That is, no person should be judged without a fair hearing. Mostly, odi altrum partem takes place in civil laws where husband and wife, they do try to fight against each other. And in India, it is used to be there because in India, wife want to overpower husband and husband want to overpower women. So this was the basis of writ in the Constitution of India. Now, the question arises, why do we need writs? Just imagine a situation. In 1599, one foreigner, that is Britisher, invaded, or we can say that he visited India. And if we take 1590 as 1600, since 1600 till 1947, India was under the rule of Britishers for long 347 years. You can imagine what type of feudal system was established in the country. We have faced foreign domination. We have faced foreign oppression. We were struggling to reborn in the life. The future was uncertain. There was heavy burden on the shoulders of Indians. India was under so many social evils, such as illiteracy. At that time, when in 1947 we got independence from the clutches of Britishers, before that, India was mostly illiterate. There was hovering around in Indian culture superstition. Sati system was there. Child marriages were taking place. Agrarian exploitation was there. You might have gone through history. that in history, Britishers have forced us to grow indigo in place of other food staple. Child labor was at highest. Bonded labor were there. Gender inequality was there. India was very, very horribly bedwelling society and polity. Just imagine if you want to overcome this type of situation, this type of ills, we need to have some sort of fundamental rights. Until and unless we have fundamental rights, we cannot say that writ can be issued. So these were the problem before 1947. But after 1947, what happens that we started this new era of the country. We established a democratic government in 1951. Thereafter, every 5 years, we try to elect the government on the democratic platform. We are having adult franchisee so that each and every individual can take part in the voting system of India. We try to choose the government. What type of government we are choosing, it is irrespective whether it is coalition government or whether it is full majority government. But all of the governments are working for the country. That is good. Now we started this, and now what is the basic problem? Whether we need to understand that without fundamental right, can a individual live his healthy life? Now my question to all of my audience is, or simply I can't put your question because this is one-way communication, so I will speak myself. You might have heard in economics one concept, complementary goods. Complementary goods are those goods which are used together. Without petrol, we can't use car. You can take another example. Just behind me, there is air condition installed. We can't use air condition without electricity. That means these are complementary goods. Now, fundamental rights and rates both are complementary goods. Because without fundamental rights, we can't live, and without rates, no fundamental right can be secured. Just imagine a situation if someone has got hold of you, he locked you, he locked you behind the bars, or maybe a private individual, he got hold of you, he locked you in a room. There is no communication between you and your parents, your friends. So your fundamental right has been infringed. Now what to do? This is where writs come into play. That is why we can say easily that writs are complementary goods, none other than complementary goods. So you might have heard one case was there, L. Chandra Kumar versus Union of India, 1997. In that particular case, Honorable Supreme Court ruled that authority to issue writs to Indian citizens, I repeat, Indian citizens, in order to uphold their fundamental rights. The Supreme Court is itself saying that the fundamental rights need to be protected. Is an aspect of basic structure. Again, there is another point, basic structure. So why Supreme Court is saying that fundamental rights and writs are part of basic structure? Because both are complementary to each other. If you take one, automatically you can take away the other. So Supreme Court very clearly dictated that you cannot amend or you cannot eliminate writs because it is a part of basic structure. Suppose that if your house is there, there is with the house is without foundation. Now you can imagine, just imagine a situation how long your house can sustain. It has very less sustainability because foundation is not firm. Same as without fundamental right and with so without right, you can't imagine a situation of fundamental rights. Who is going to protect us? Now, assuming a condition, say that what was the name of that guy actually? Pragat, the host, that one who was there.
So Tarang.
Tarang. We will take example on Tarang. Suppose Tarang has been taken as a hostage and Tarang has no communication. But one of his friend was aware that Tarang was going along with, say, person A. Now, in this situation, Tarang is unknown to anyone. Now, what will happen? His father, his parents, they will be in doldrums where my son is there. Where and Tarang's relative will be in doldrums. They will try to find out. They will run from pole to post to find out Tarang. But one person who has idea that Tarang was accompanied by person A. Now, whether writs can be issued or writ can be set into motion by Tarang or that particular person A, then answer is both can go for writ. This clearly indicates, I will give one example. One of the very public spirited lawyer is there, Prashant Bhushan. Mr. Prashant Bhushan is very much interested in public interest litigation, and because of this only, he always tries to ignore to take the tag of senior advocate of Supreme Court of India. And number of times he has been included in the list of being a senior advocate, but he tries to ignore that on the basis that if he being accorded a senior tag from Supreme Court of India, he can't file PILs because senior advocates are not supposed to file any litigation. They can only defend or they can only proceed in the litigation. So a public spirited person can also go for filing a writ along with the person who is having some sort of issues. If Tarang is having issue, he can go. If Tarang is having issue and Tarang is finding himself very poor, he is very pauper, he thinks that if I go for filing a writ, I may be created some problem with some with other person. So a public spirited person can also file writ against the state. Now the question arises whether writ can be filed against state or against a private individual. Then it depends. Then it depends on the situation and case to case basis. In one of the cases, even the private individual was being issued writ by the High Court. I will quote one case, Sheila Barse versus State of Maharashtra, 1983. The court expanded the scope of writ by adjudging that it is not necessary that detainee, in our example, detainee was Tarang. The detainee should be the petitioner. An interested party who has some connection with the case may also do so. I repeat, who has some connection with the case. Again, I repeat, who has some connection. It may not be your relative or it may not be your parent, any person. So in the case of Tarang, the one person who has seen that Tarang has been accompanied by A can file, that particular person who has seen Tarang can file writ petition. That is, that this should be very much clear to all the citizens of India because right now what is happening, we can say that the current government, I don't want to criticize the current government, but still, for the sake of example, we can take that current government is using the institutions of ED and CBI to harass people. It is only for the sake of example. I'm clearing myself that I'm not criticizing government because it is the prerogative of government. They can use these instruments. So if government is harassing you, so what remedies are there? There are two remedies. You can go to file a writ in high courts of India, whatsoever high courts are there nearby you, or directly you can approach Supreme Court. Now there was one case whether you can file writ directly to Supreme Court or first you have to exhaust the remedy of High Court. So Supreme Court reiterated in n number of cases that first try to exhaust your remedies, then come to Supreme Court because Supreme Court is full of loaded of the cases. So they can entertain. They are not denying that we can't entertain. They can entertain, but for the sake of brevity, they say that you first try to exhaust all of your remedies. So Sheila Barse versus State of Maharashtra 1983 clearly indicates that a public spirited person can also file a writ. Right. Uh, Most of the time you might see that in Delhi it is very cold out there in Delhi. Some persons are there who think that those who are homeless, those who are poor, those who are uh, sleeping on the footpaths, they are also human being. They are part and parcel of the country. They are the citizen of the country. They are having fundamental rights. Just because they are poor, they can't approach courts. So a public spirited person can file writ against to protect their fundamental rights. Under Article 21, right to food is a fundamental right. Being a poor, it is the duty of the state. Now, you being a poor, you can't go, you can't approach High Court, you can't approach Supreme Court. Then a public spirit person like Tarang, or maybe we can take example of Prashant Bhushan ji, they can go to file a writ against to protect the citizens of the country. Now, next question is whether there is any time limit for filing a writ. Just imagine a situation, is there any time limit of life? Then the answer is no. Even I can die speaking because after COVID, there were a number of cases, people dying while they were walking, people died while they were going to gym. So if there is a question related to life, life can end at any point of time. That is why Supreme Court has reiterated that there is no time limit. The moment you feel that your fundamental rights are being infringed, you can file writ. So, but strictly they say that there should not be unreasonable delay. You can't say that, sir, I was to file the writ against that particular police official, but unfortunately, I was there attending a marriage ceremony. This is not a reasonable ground. You can't say that I was there with my girlfriend. That is why I failed to file the writ. This is unexpectable, and it is not expectable as well as acceptable as well. Inordinate delay should not be there, and the delay must be justified. You need to justify that. Otherwise, Supreme Court will not entertain your writ. Now the question arises where we can file writ. The Constitution of India is very clear at this point. It says that if you want to approach Supreme Court, then you need to take the course of Article 32. Now, if you want to approach to High Court, then you can take the course of Article 226. There are two ways you can go for filing a writ, under 32 and under 226. Now, there is one debate. Supreme Court being the highest court of the land, and it is only one in India. There are n number of high courts. Now, whose jurisdiction is more compared to in relation to writ? If you ask this question to a layman, then he will say that, sir, Supreme Court will be having largest jurisdiction because he has to serve whole India. But for a kind information, under 226, the jurisdiction of High Court is much more than compared to the jurisdiction of Supreme Court. Say, for example, if your fundamental rights are infringed, then you can approach under Article 32 to Supreme Court. I repeat, fundamental rights are infringed. Then I say, only fundamental rights are infringed, then only you can approach under Article 32 to Supreme Court. And if your fundamental rights are infringed, you can also approach to High Court. At the same time, for some other causes also, High Court can entertain your writ. That means, say for example, if you being a private party, because mostly when you study some short books while you're preparing for UPSC or you are preparing for judiciary, you go visiting some books like Lakshmikant and short of form of Didi Basu, or say for example, we can take example of that Lucent also. But they are very concisely written. We can't say they cover the topic very exhaustively. They are inclusive, not exhaustive. So the question arises whether against private individual can we file writ in Supreme Court of India. Then your option is no, you can't go. But you can't But you can approach to High Court when you are going to file a writ against private individual. This is where we must be very well aware. Now, coming to different types of writs. So normally there are five types of, as we know. One is habeas corpus, the Latin term, which means to have a body. Another is mandamus. Again, it is a Latin term that means to command. Quo warranto, again Latin term, by what authority? And certiorari, in again it is a Latin term that means to certify, and prohibition, but this time it is English term that means to forbid or to stop. So why we always try to use these Latin terms? That is very simple, because they are advanced countries and all the advanced countries are advanced in law as well. So they have created their own law. We try to copy from their law, their books of law, whatever constitutions are there. Now I'll discuss first what is writ of habeas corpus. As we already know that habeas corpus means having the body. We will take one example to understand what is habeas corpus. Suppose that police has detained you without any reason. Now, can a person approach to High Court filing a writ that that particular person must be released because he has been detained without any reason? Then the court will entertain. And under Article 20, it is clearly mentioned that no person can be detained, or if a person has been detained by police official, he must be taken to the nearest court within 24 hours. But be careful, if police has detained you having a reasonable ground, then you can't file a writ. Then you can't file a writ. Why? Because the police is having some ground to detain you. On that ground, they can detain you. Now, why we have included this to have a body? Because sometime what happens, especially I will take an example of Uttar Pradesh. In Uttar Pradesh, police officers try to involve the name of that particular any individual into gangster act. And one speciality about gangster act of Uttar Pradesh is that you can't go for bail. There is no bail option in gangster act. So now, what remedies are there to the victim? And most of the time, a number of lawyers they don't know, and sometimes they fail filing SLP or simply for a 439 and 437 in high courts, and high court denies them bail. The remedy is you can file a writ against Gangster Act. So those who are young and practicing lawyer, if you come across this type of case, any individual has been included or he is involved or he has been falsely implicated in Gangster Act, then you can take a recourse of writ and you can set him free. Now, Article 21. The writ is used to enforce the fundamental right of a person, that is, the liberty of person, under Article 21 of the Constitution. Why? What is Article 21? Article 21 is right to life. Right to life means right to live a free life without any hindrance. But it doesn't give you any license that you can create nuisance. I will quote one example of uh, movie Agni Sakshi. In Agni Sakshi, what happens that the neighbors of Nana Patekar, they were enjoying party, and Nana Patekar was also invited in that party. Nana Patekar was also invited in that particular party. He denies. Whether I am audible, because none is appearing on his screen. That is why I think
Yes, you are audible.
because none was there on his screen. Na? So what happens in that movie? Nana Patekar used to fire bullets on the speakers, but after 10, because he was well aware of the law and rule. That means until and unless your until and unless your fundamental right is infringed, you cannot set the law into motion. In that movie, Article 21 clearly indicates that it is the fundamental right of an individual to have a peaceful atmosphere around him so that he can sleep and he can think about his family, he can talk to their family members, and there are a number of things. But if you are celebrating Ganesh festival at night at 2 p.m. You are celebrating your marriage anniversary, or you are arranging a marriage ceremony. You are arranging some ceremony like birthday parties are there. You try to beef up the speakers. You try to infringe the fundamental rights of other. So be careful while you doing this type of nonsense activities like Nana Vatekar. So if any person who has infringing or fundamental rights under Article 21, that is right to life, then you can approach Supreme Court or High Court and so on. Now, the question arises, in which situation can the writ be issued? That is, habeas corpus writ can be issued. First, when the detention is not in accordance with the procedure established by law. When the detention is not in accordance with the procedure established by law. That means if there is a procedure under CRPC 154 that first of all a complaint must be filed, and on the basis of that complaint, criminal complaint, the law is set into motion and you can be detained. But without any reasonable ground, if someone is detaining you, then you can go filing writ of habeas corpus. Second is, when an arrest is made under a law, itself then it is itself unconstitutional. That is, when an arrest is made under a law, itself is unconstitutional. Why? Because the law says that it should be reasonable. You can't implicate anyone. You can't implicate anyone on whims and fancies. It infringes your fundamental right. Now, third is when the procedure established by law is not strictly followed. Not strictly followed means, say for example, FIR is lodged. I will quote one example. Earlier, under section 498A of IPC, that is related to some cruelty to wife or maybe dowry. Women, they used to file FIR under 498A. Police used to catch hold of the person against whom the FIR is being lodged. They are put behind the bars and they need to take bail. Now, what court has arrived at a conclusion that according to NCRB report, 82% of the cases lodged under 498A are false and frivolous. On the basis of this, Supreme Court has said that if any person is lodging FIR under section 498A of IPC, first police has to conclude themselves that whether this case is perfect to take the person into custody. If not, then they should only issue warrant that you must visit court and take bail and so whatsoever things are there. So be careful because of this only. Because of this only, NCRB data clearly indicates that more than 82% women are losing their cases in different courts. Why? Falsely implicating. They are using the law for their whims and fancies. They should not be accepted. That is why Supreme Court and High Courts are very strict on this. Now, the question arises, in what situation writ cannot be issued? The writ is not available during the proclamation of an emergency. Suppose that there is emergency in the country. At that particular time, you can't say that my fundamental rights are being infringed. But be careful. Even during emergency, if your fundamental rights which are falling under Article 21, that is right to food, right to medicine, right to see a doctor, then you can set the law into motion. You can file writ. It is not exhaustive. Again, I say it is not exhaustive. With time and again, Supreme Court has said that clarified that these are the things which are included under Article 21. These are the things which has to be excluded from Article 21. Secondly, the writ is not available if the writ petition is dismissed by the competent court. That means you filed a writ petition in High Court, they're dismissed. Then you cannot go filing another writ in Supreme Court of India. Thirdly, the writ is not available when the detention of the person is related to the order of the court. Say, for example, if the court has order and it issued summons to an accused that you must be present in the court on so and so date. And if you fail to comply the order, then at that particular point of time, police can catch hold of you and you can't file writ because you are catch hold of by police. It is because of the order issued by the competent court. I say competent court, that means any court, not only High Court. The writ is not available when the confinement of the person is shown to be legal by providing the necessary evidence. Say, for example, suppose that when the law is set into motion and you have been awarded 1 year of confinement, then that it against the confinement because you will take an Ram, a person who was in the custody of B. Ram, you can replace this name as well. A police officer without a warrant to arrest Ram. B did not present Ram before the magistrate. That means B being a police officer, he catches the person, but he failed to present that particular person in front of the court. Now, that particular person can file a writ. But if police is catching hold of that particular person on the reasonable ground, he can't file it. This was all about habeas corpus. I will deal some relevant cases to that. And you being aspirant of law and maybe some of you might be preparing for judiciary as well. There is one case, Kanu Sanyal versus District Magistrate Darjeeling, 1974. In that particular case, the court said that there should be focus on examining the legality of the detention according to the facts of the case. That means each and every time you catch hold of a person, there should be legal ground. Unreasonably, you cannot arrest any person and you can put behind the bar. Another interesting case was Lalu Bhai Jogi Bhai Patel versus Union of India, 1980. It was held that second writ petition. Again, I say it was held that second writ petition could not be issued if it is filed on the same grounds. If it is filed on the same ground as the first writ petition. Why? Because if this is so, then this will be unending litigation. Every time you fail from High Court, you approach to Supreme Court. Again, if you fail to Supreme Court, again you will try to file in another High Court. In Sunil Batra versus Delhi Administration, 1917, this is very interesting case. The Supreme Court had widened the scope of writ of habeas corpus and held that the writ cannot only be issued in case of unlawful detention, but it can also be issued against ill treatment of prisoners. That means there are some instances wherein the person who is under detention by police officer or maybe on the award given by the courts, if you're serving your sentence behind the bars, then being an human being, you are having some fundamental rights. And just because you are accused, the fundamental rights cannot be waived off. That is why each and every human being on earth, whether he is behind the bar or outside the bar, has fundamental rights and it must be protected. And it is the duty of the courts to protect it. So in Sunil Batra case, Supreme Court has directed that
each and every jail authority must take into consideration all the facilities related to the prisoners who are under detention. Now I will take writ of mandamus. As you all know, this writ is against the authority, higher authority directing the lower courts. Say, for example, high courts to lower courts, or any public servant, high court to IAS officer, IPS officer, or whatsoever, who has failed to perform their duty. You approach to district magistrate, in example, and you say that, okay, sir, in our area, COVID cases are increasing. And the district magistrate says that, okay, it is not my duty. You go and approach to chief medical officer, because I am not medical officer, I am district magistrate. You are wrongly in front of some person. So at that point of time, you can approach under writ of mandamus to High Court and Supreme Court, directing that, sir, the court will be directing to district magistrate that, being a head of the district, it is your responsibility to entertain the problems of all the individuals which are related to your district. You can't deny, you can't say that ki, just because I'm not a medical officer, I can't entertain you. If you can't entertain, okay, we can understand. You know, you are not a specialist in medical terms, so you can at least order, you can at least give an order to chief medical officer to go and entertain the person. It is your duty. Second is, the writ is the last resort. That is, it is issued only when all other attempts to solve the problem have been made. Say, for example, assuming that if you approach a hospital and they deny, and again you approach another hospital and they accept that, yes, we can entertain your problem, and they provide you all the facilities related to your ailment or whatsoever problem you're having, physical, mental, or any health issue. If your problem has been solved, then you can't go filing a writ against the first person who has denied you. That is, say, for example, hospital A, you approach first, they denied, you approach hospital B, your problem is solved. Now, after your problem is solved, you can't file a writ of mandamus against A, because finally your problem has been solved. That means you have exhausted your remedy to filing a writ petition of mandamus. Now, the next is, in which situation can a writ of mandamus be issued? So, first is the person or any public authority, I repeat, any public authority against whom the writ has to be issued must be under an obligation, again I repeat, obligation by the law to perform certain duty. That means, suppose you are being given an authority and you are being appointed by some authority of the state, then you are under obligation. But if your duty is discretionary in nature, if your duty is discretionary in nature, then writ can't be issued against you. So most of the time, what happens? Some persons are appointed on ad hoc basis. Then it is discretionary. You can't file against them. There is an sorry. I'm connected.
Yes.
Sorry. Just a moment.
Now audible?
Yes, sir, audible.
Okay, sorry. Actually, there was one call. Now, in which situation writ cannot be issued? The writ cannot be issued against the judges of High Court. You can't say that you, being a judge of High Court, it is your duty to look after our cases. No. And the Supreme Court, you can't compel them. The writ cannot be issued against the President of India, against the governor of any state, to compel them to perform their duty. Why? Because these are the authorities which are performing some sort of obligatory and some sort of discretionary. You might have seen that the judges are having discretionary power to discuss or to solve any matter or any cases. The writ cannot be issued against working Chief Justice of India. Against working Chief Justice of India, you can't say Chief Justice of India currently. The person named is Honorable Chandrachudji. You can't say that it is your duty to entertain our writ petition. No, the writ cannot be issued when the nature of the duty is discretionary. As I have already cleared you, this writ cannot be issued against a private individual. Why private individual? Because he is under no obligation to entertain your queries. The writ cannot be issued to enforce a private contract. What do you mean by private contract? A contract between two simple individuals. Say, for example, between me and Tarang, if we have contract to buy and sell mobiles, Tarang, or if I default in that particular contract, you can't say and you can't file writ against me that it is sir, you are under obligation according to the contract to perform this particular duty. You have to sell this phone, and if you fail to sell this phone, then you will find yourself behind the bar. No, you can't issue writ for private person. I will deal one of the cases in EA Cooperative Society versus the state of Maharashtra. The state government had denied the jurisdiction to revise the order of the lower authorities. The issue was to grant membership in the society to the respondent, which was first denied and then accepted by the registrar of the society. Hence, an application for the issuance of the writ was filed in the concerned High Court, that is Maharashtra, that is Bombay High Court, failing which the respondent reached the Supreme Court by special leave petition. It was held by the Supreme Court that writ of mandamus can be issued where a public servant has denied its jurisdiction which it has under law. That means, again, there is another very interesting thing. If you are having any doubt related to your rights, and you are questioning, and if you want to resolve that particular doubt from the authority who is not under your jurisdiction, then you can't go for issuing writ of mandamus. Another case was Sohan Lal versus Union of India. The government of India, this is very interesting case because it was related to refugees of Pakistan. And whatever things are related to Pakistan, we are very fond of that. The government of India allotted plots to the refugees from Pakistan, provided they met the eligibility criteria set by the government. Say, for example, you are coming from Pakistan, you left some portion of your property there in Pakistan, and you don't have anything to live in India. That is why if these criteria are met, then you can file writ petition. However, the appellant was evicted from his allotted plot, and thus a petition was filed by him for the issuance of writ. Supreme Court said that a writ of mandamus can be issued against a private individual provided the private individual has merged with the public authority. That means assuming that there is one housing complex, and if that housing complex has been taken up by the government of India, then again you can file writ petition under writ of mandamus either in High Court or either in Supreme Court for the issuance of writ. Next writ is writ of quo warranto. This is very interesting. This writ is issued asking public servants to prove under what authority they are holding a certain public office. Especially, I have heard one example that one of the person, he was very layman person. What he did, he has somehow wrongly taken the name of IAS officer, and under the name of that IAS officer, he started making money. Now, at a point of time, he has been caught by the police. Now they started inquiring whether he is real IAS officer or not. And what has been found that he is merely performing the duty on the guise of some other person. GUISE guise means he was cheating. And if you're cheating some person, Being an layman in the guise of being a public servant, then writ is against you and writ can be issued against you. Now, on whom the burden lies? Whether the person who is resorting for it or the person who is not performing the duty, the burden of proof lies on the concerned person. That means that particular false IAS officer. The writ prevents any person from wrongfully usurping a public office without any authority. Wrongfully usurping a public office means what? That means if you are legally entitled to hold an office, you can. And if you are not legally entitled, you cannot. Say, for example, in the Constitution of India, it is very clearly mentioned that if you are elected, you can hold office. And if you're not elected, still you can hold office. But within a specific time, you need to get elected, either from Lok Sabha or Rajya Sabha. And if that particular stipulated time has been covered or has been, we can say, waived off, then you can't hold that office. I will quote one example. Mr. Manmohan Singh, the erstwhile Prime Minister of India, who failed to get elected from any of the constituency, he was nominated from the Rajya Sabha. Then only he can become Prime Minister of India. This is where we must be very careful that according to law, you have to fulfill the condition to hold that public office. Now, in which situation the writ cannot be issued? The writ can be issued. First thing, this writ can be issued if the office is created by law. If the office is created by law, that means if whatever, say for example, district magistrate, this is the office created by law. Commissioner of police, office created by law. If these offices are created by law, then only you can issue this writ. Second is the public office must be substantive and permanent in nature. What do you mean by permanent in nature? That means the office or the institution remains intact and the person who is holding that office, he may be removed from that particular thing. See, I will give an example. Prime Minister is the office. Mr. Narendra Modi is the person. The office is permanent, but the person is not permanent. The very next year, maybe somebody else can be there elected in that particular office. Second important criteria is the position in a public office may be unlawfully held by a private person. That means the person who is holding that office should be unlawfully holding that particular office. If it is illegal, then we can issue this writ. Next is there has been a contravention of the law. That means the law has been infringed. Next is the duties arising from public office must be the duty must be public in nature. That means you must be under obligation to perform duty not for individual but public as a whole. If these things are met, then only a writ of what is this? Which writ? A writ of quo warranto can be issued. Now, whether there is any condition, in which condition that this writ cannot be issued, then there are two conditions. First is the writ cannot be issued if there is any political gain to be petitioner by the issuance of this writ. Say, for example, recent very nice example of that Maharashtra government. In Maharashtra, there was a problem of who is going to become the chief minister of Maharashtra. If that particular thing is unlawful and illegal, then it cannot be issued against that particular body. Why? Because you are very much interested in that particular post only and only to gain money or to gain power. For your personal purpose, you can't use this office. Second is, writ cannot be issued against any state minister. Why? Because state ministers are elected and they are moved off from their position the very next election. One case is there, University of Mysore versus C.D. Govinda Rao, 1963. The university had appointed a person who was not meeting the eligibility criteria required for the post. As a result, An application for the issuance of writ was presented before the Honorable Supreme Court. The Supreme Court we said that the office against which the issuance of writ of quo warranto is paid for must be of substantive in nature. That means it must exist and it must be a permanent. It should not be temporary in nature. Mostly this happens. I can quote one example in recent government. Recently, government has enacted a law that is uh, some entry of IAS officers, 31 IAS officers have been included in Government of India under the banner of lateral entry. Under lateral entry, 31 IAS officers who have been directly posted to Chief Secretary. If they are not meeting the criteria, whatever the criteria, they must hold MBA degree, they must be working for 5 years. And if one of the person who is having MBA degree from private institute, that is through correspondence, is not entitled to hold that office. And if any person who is public spirited, he files the writ against that particular officer, he will be removed from the office. Next is writ of certiorari. This writ is issued by higher courts, that is Supreme Court or high courts. Higher courts means it may be session court to the lower courts also, directing a lower court to transfer a particular case to the higher court for consideration. Why? Because there are certain instances in India that same person is filing different cases, the same cases in different courts. And if court came to know that this person is misusing or he is trying to confuse the courts, they try to club all the cases at one particular place so that it can be easily solved. Secondly, the higher court also have the authority to quash an already passed order by the subordinate court. For that, you need to approach the high court under appeal. The writ aims to correct the mistakes made by the judiciary at the lower level. Yes, this must be there. Why? Because if some lower courts are doing some miscreant or they are doing misjust or they are not doing the justice against the person, then what remedy the person is having? The person must approach the higher court so that it can be corrected. In what situation this writ can be issued? First is it can be issued when a person is bound by a legal authority. Secondly, the person acts beyond its jurisdiction. Say, for example, jurisdiction of a court is Allahabad district. And if you are summoning or if you are summoning some person who is beyond your district and that too illegally, then you may be called in for the question that on by what authority you are summoning this person. The writ can be issued when a person is acting judicially, commits an error of law that is very apparent. If there is a law error, then you can issue this writ. If the writ can be issued when such a person has committed fraud, that is, it has violated the natural justice. What do you mean by the term natural justice? Natural justice means that we all are human beings, that we should not be cheated by the individual or the human being by themselves. Why? All human beings are there on this earth so as to cooperate with each other, so as to develop the society as a whole, so as to develop the country, so as to develop the nation as a whole. And if we start cheating against each other, the uh, then the dream of developing the nation, dream of developing one whole world will be under problem. There is one concept in India, Vasudhaiv Kutumbakam. Vasudhaiv Kutumbakam is very interesting thing. Assuming that the whole world is one family, only and only the family exists when each and every member of the family cooperate with each other. You can take one menace that is terrorism. Terrorism is one of the factor which is trying to disbalance the spirit of the family of the universe. Now, there is the last writ, that is writ of prohibition. I will not take too much of time because Legal things are very much boring until and unless you face that legal situation. It creates some boring. So this is last of the writ of prohibition. This writ is issued to prevent a lower court or a tribunal to acting beyond its jurisdiction. That means you being a court and you want to assume that you being a lower court assume that you are supreme court and you are acting beyond your jurisdiction. This is not acceptable because each and every jurisdiction has been clearly defined in the constitution, laws and bylaws of India. And if each and everything is being clearly defined, then how come it is possible that you can encroach the jurisdiction of somebody else? That is, if you're encroaching, then writ of prohibition, that is, warning is issued to you that you can't go beyond this limit. If you are very fond of watching movies, you might have seen that if a person has been shot dead or if a person has been killed and the person has been killed on the border of two jurisdiction, then the policeman will take hold of that particular body and they will throw in the different jurisdiction so that their problem can be put on other jurisdiction. This is very much common in movie, but in reality this doesn't happen. Why? Because fundamental rights are there. The writ can also be termed as stay order. Why stay order? Because you are encroaching the jurisdiction of another court. I will quote one example. In the case of S. Govinda Menon versus Union of India, several allegations of dishonesty were made against the appellant, which were also to be inquired about by the government. As a result, a writ petition was filed to quash the proceedings initiated against him. The Kerala High Court held that the writ of prohibition can be issued in both situations, excess of jurisdiction and absence of jurisdiction. That means if you don't have jurisdiction, you can't comply it. And if you have crossed your jurisdiction, then also it can be issued. Another matter is there, Hari Vishnu versus Syed Ahmed Ishaq, 1954. The appellant was nominated for the election of Rajya Sabha, representing the state of Madhya Pradesh. The appellant won the election, but an issue was raised that the ballot papers did not contain the distinguished marks, and the election of the appellant was terminated. The difference between the writ of certiorari and prohibition was given by the Supreme Court. The court was of the opinion that one can file for the writ of certiorari only after the judgment of a particular case has been delivered. And on the contrary, one can file for the writ of prohibition when the judgment of a particular case is still pending. The court further ruled that fresh election must take place. That means in this particular case, what happened? That a person has been elected, but unfortunately, what was the issue? That the ballot paper was not indicating the marks which was related to that elected person. So the decision has to be taken in accordance to the law. So from my side, I'm going to end this particular session. I feel that it might be a boring for some of the students or some of the aspirants. See, anything which is related to study is, of course, boring. If you want to gain knowledge, it is boring. One of the time, my father said that in Hindi, I will repeat this word. जब तक मैं जिंदा हूँ बेटा ऐश कर ले और जब मैं मरूंगा तब तुझे पता चलेगा. And this really makes sense. If you want to gain something, it must be boring, but you have to gain that thing. Otherwise, what will happen? The time you are missing, it cannot be ever make up. You can't make up your time. So don't waste time. I wish all those who are attending, and who left in between. I don't know whether there were how many person was attending this lecture. But still, I wish that if you are attending any of the lectures throughout the world, you must attend attentively and to the fullest of your energy. Yes, now it is time. If anyone wants to ask any question, so all the questions are welcome.
Sir, it was indeed a very fruitful session. Though we have got few questions, but you majorly asked few of the question, but yet there are few questions which need to be answered. Sir, if you permit,
Hmm.
can I proceed?
Yes, yes.
So, sir, the very first question is writ and Article 227 of Constitution. What's the correlation between both of them?
Sorry,
So, the very first
article.
question is Article
Hmm.
227.
Hmm.
What's the relation between writ and Article 227 of the Constitution?
So what is Article 227? First of all, we need to understand what is Article 227. Article 227 is every high court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Second thing is, without prejudice to the generally for the or foregoing provision, the High Court may call for return from such courts, make an issue general. See, this particular section is specifically mentioning that High Court is having some power. It doesn't mean that High Court is having, where is Article 226? It clearly indicates that High Court is having power which is very much constrained. That means only and only writ and other things can be entertained under Article 226. And that too, it has to be related with your fundamental rights. And if your fundamental rights are infringed, then only you can take course of 226. And for other purposes, you can take course of 227. So it was in the very beginning of my lecture, I have already cleared that fundamental rights are the essentials related to rights. So next is,
Okay, sir. So the very next question is, can writ petition be cancelled?
can petition be?
Cancelled, sir.
Yes, of course, petition can be cancelled if you're filing writ against writ. Suppose you failed your petition in High Court, it can be cancelled in High Court. And if you are filing writ petition without having any jurisdiction, without having any legal force behind that, it can be cancelled.
Sure, sir. So you have answered major of the question we have got. Sir, in closing, I
Mhm.
would like to heartfelt gratitude you for coming and delivering such an informative session. I believe, along with all the participant believes that it was very informative session, very fruitful session as well. So we look forward to come address you again and deliver such a fruitful session. So thank you so much.
Thank you very much, and I wish all of the members of Just Corpus to have a nice time ahead in the near future. And I'll be very glad to be serving this platform in the near future as per my time permits. Thank you again and have a nice time. Good luck.
Thank you, sir.
Thank you so much, sir.